The Judicial Committee of the Privy Council has ruled that Trinidad and Tobago's death penalty will not be abolished. A challenge to the constitutionality of this law was brought before the courts by the Death Penalty Project, but the case has been dismissed. Dike Rostant tells us more.
If this challenge to the constitutionality of the mandatory death penalty here in Trinidad and Tobago was successful, it would have impacted all those on death row in this country, making them eligible for resentencing. The non-governmental organization Death Penalty Project, based at Simons Muirhead Burton LLP, mounted the challenge as part of the appeal for their client J. Chandler, who was sentenced to death by hanging in 2012 for the murder of Kern Phillip. On October 8, 2004, Phillip died after being stabbed, while both men were serving sentences at Golden Grove Prison, Aruk. The organization appealed Chandler's death sentence on the grounds that imposing the punishment automatically was unconstitutional. However, in Monday's ruling, Lord Hodge, one of the most senior judges on the Judicial Committee of the Privy Council, said that it was not a question for judges in London, but for Trinidad and Tobago's Parliament. The mandatory death penalty is an automatic sentence of death for every person convicted of murder under Trinidad and Tobago's Offences Against the Person Act 1925. To date, Trinidad and Tobago is the only country in the English-speaking Caribbean that retains the mandatory death penalty. There have been no executions carried out in Trinidad and Tobago for over 20 years, with the last hanging taking place in July 1999.